Good morning.
This is case number 2009-0751 in the matter of Martin F. Kurowski and Brenda A. Kurowski.
Because today is the governor's inaugural, we're having a truncated session, unlike the one we originally planned, so we will take the three appeals this morning in order without taking any recess until they're all completed. And I will remind the new court that counsel are supposed to be entitled to 3 minutes of uninterrupted argument, but I'll also remind counsel that sometimes we can't help ourselves. Please proceed.
May it please the court, I'm Joshua Gordon. I represent Marty Kurowski, the father who is here today. This case is not about religion or even about education. It's merely parents who differ about child-rearing philosophies. Ms. Voydatch wants the child cloistered. Mr. Kurowski believes she should be more worldly and more widely exposed. He would be insisting on that sort of
Why does a court
exposure.
get to make that value judgment for either parent?
Pardon me?
Why does a court get to make that value judgment for either parent?
What value judgment is that?
The one you just articulated.
That a
Cloistering
child
versus non-cloistering, let's put it that way.
Well, sure, cloistering. Well, he'd be insisting on this non-cloistering regardless of the reason, but what the court understood and what Mr. Kurowski suggested to the court is that he believes, and to answer your question, that success in life requires a set of life skills that ought to be acquired in adolescence, confronting unfamiliar situations and attitudes, advocating for one's position, assimilating the positions of others, parsing new ideas rather than taking them unquestioned, group decision-making.
But you're not answering Justice Hicks's question, which is, why should the court get stuck making that choice?
Well, there's a dispute between the parents.
But why doesn't the modification statute take care of that problem by eliminating the venue for the dispute?
Well, this isn't a modification, and I think that's fairly clear from the record below. In 2006 proceeding, I mean, if you want me to talk about modification, that was a proceeding for contempt, and Mr. Kurowski alleged that Ms. Voydatch didn't adequately consult him on education, and the court said, yes, she did. The 2008 proceeding was a stipulation approved by the court that the parties would meet to discuss the transition to public school. That is, at most, an order to meet and talk. It is not a decision on how the child would be schooled.
And so, since they couldn't agree, the court has to decide.
They couldn't agree, the court has to decide.
And so it's not a modification in that sense, it's just a resolution of the dispute between two parents, which courts do all the time.
Precisely, Judge. It's not a modification. There never was an existing order.
And so you disagree with the proposition that changing the status quo cannot be viewed as, from a legal standpoint, as a modification?
It was correct. It was only a change of practice. It was not a change of an order. And the modification statute says, quote, the modification says, to number 11, 461A11, the court may issue an order modifying a permanent order concerning parental rights and responsibilities. There was no order here. There was a practice, but there was no order ever entered by a court.
Put the shoe on the other foot. Suppose the child had been going to public school for those years, and one parent decided she ought to be homeschooled after all of those years. The order is silent about what the schooling is, but on the ground, it's obviously a modification of the status quo.
It's a modification of the status quo, and
So
would be
why
in best
doesn't
interest.
the modification statute control?
Because there's never an order on the issue. It would be a best interest decision and not a harm decision under much more.
So your position is this would be analogous to parents who had informally separated, and the child went with one parent, and then when there was the first divorce hearing or final divorce hearing, the court looks at the best interest of the child and does not look at what was done informally. That's your position. There has to be an initial court order.
In order for the Muchmore statute to apply, there
Correct.
has to be an initial court order.
If you're right, why is it necessarily in the child's best interest to stop being homeschooled?
Well, this was the question I thought I was answering before. Mr. Kurowski believes that the child needs to be more fully exposed, working with peers, in differing interests and abilities, understanding and coping with diversity, finding out how to be individually successful in comparison to others, dealing with non-family authority and non-family rules, independently meeting deadlines. Calling this socialization is not in accord with the record. Mr. Kurowski's concerns were much broader than that. He wants his child to acquire these life skills, but understands they are not being effectively accomplished in Ms. Voydatch's isolated homeschooling environment.
It sounds, though, like reading the order that the court took into account religion. Is that impermissible?
I don't think the court took into religion. There was obviously the reason for the parents' difference of opinion is religiously based. But religion, the court was very clear that, and uncomfortable, expressed its uncomfort at mentioning religion at all, and said, I'm not looking at the...
There seemed to be a concern, and as I have it from the testimony, the child was upset with her father, worried that because he didn't hold the same religious beliefs, they weren't going to live together, for eternity. They weren't going to be together for eternity. I mean, that was expressed in the court's decision, and she had a concern about that because of the child's worry that if the father didn't believe as she believed, then they wouldn't be together eternally.
That's correct, and during the hearing, when there was an objection to religious tenants coming in, the judge said, well, I'm going to let them in for precisely that reason, because the child has expressed a difference of opinion with the father's religious beliefs, and that's getting in the way of the father's parenting. And the reason that the homeschooling is a problem is because of this isolated learning that she's having, and it's causing her to withdraw from her father. To remedy this, there really are only three options. The first is a parochial school, but there are only a few in the area, and of those, Ms. Voydatch testified that none sufficiently comport with her beliefs. The other possibility...
If I could go back to Judge Duggan's example before, suppose you have the situation where, one parent is Catholic, let's say, and the other parent is Jewish, and they're both, good parents, but they vehemently disagree with each other as to what religion the child should be brought up in. In that circumstance, doesn't the court, somebody's got to make the decision. The parents can't, presumably in that situation, it has to be, the court has to make the decision. And if that's what they're arguing about, doesn't the court, in some sense, have to make a decision on that?
The court has to make a decision, but your example is even more difficult than this case. This case, there is an alternative. There is a public school alternative, which is sort of an agnostic alternative. In the, what religion is the child going to be brought up in, there might not be that's a harder case than we have here.
So if an order requires a child to go to public school, your position is that doesn't preclude the practice of the child's religion. So that's the basis of your arguing this is not a religion case. It's
not a religion case. The court was very specific in saying this order does not preclude either parent from teaching child any religious practices. This is simply an education thing. And what exactly is the alternatives? The possibility, a second possibility is homeschooling coupled with more parenting time with dad, giving him, therefore, greater opportunities to broaden her horizons. And one of the counselors suggested this. Mr. Kurowski was open to it. And in fact, that in his initial petition to modify parenting is what he requested. The problem is it would entail a modification of the parenting plan by moving the child to changing the visitation schedule and all that, and that, of course, is a much more issue. And given that given that mother lives in Meredith and father in Portsmouth, it's really not geographically practical.
So you're saying that the court could not change the visitation schedule, but could make the decision on which school to send the child to?
Well, there was an existing. That's correct. There was an existing.
It just seems like an odd result, frankly.
It's an odd result, but that's only because the history of what had happened before. There was an existing parenting plan, parenting schedule, who gets the child at what times, that's an order. There was no order on schooling. It was something that was deferred from prior.
So you agree with the court's order on reconsideration that there's a reasoned basis for making a distinction between residential responsibility and decision-making responsibility?
Exactly, and the statute makes that distinction. There is a distinction, and I think one of the amicus suggested, well, the child should just go with whatever the residential parent suggests. And the statute just doesn't allow that. The statute makes this very clear distinction between residential responsibility and legal responsibility. This is an issue of legal responsibility, not of visitation.
Well, the controlling parenting plan, it seems to me, is ambiguous because it does make a reference to schooling, but no one seems to know what that reference meant.
Well, the reference, there is an ambiguity that was raised late in the process, whether it meant schooling generally or whether it meant just the add-on courses. But I think that ambiguity doesn't really matter. The order says there was the order says at most it was an order to get together and talk. It wasn't an order to take any classes. It wasn't an order to go to any particular school or get any sort of particular education. It was just an order to talk. If there's no other questions, I'll sit down.
Thank you. Anything to add, Mr. Simmons? Case submitted. Counsel may